Hello everyone. Today let's discuss about legality of object under the Indian Contract Act. Let us look at the content. First and foremost, I'll go forward with the introduction and then I'll discuss about the unlawful agreements as well as void agreements. Then we'll focus on section 23 of Indian Contract Act which give out situations which can be termed as unlawful agreements. And then I'll be concluding my lecture. So there are few essentials of a valid contract which have been mentioned under Section 10 of Indian Contract Act. They are offer, acceptance, consideration which should be lawful, object which should be lawful, competency of parties, free consent, and the agreements must have not been expressly declared as void. We will focus on legality of object today. I have discussed about the various essentials of a valid contract in my previous lectures. Kindly check out those videos. I will give you an illustration. Let us suppose that there is a company which wants to produce electricity using the wind energy. They put up a proposal to the state saying that they want to become one of the suppliers of electricity using the wind energy and they erect windmills. The object behind the contract was that they wanted to produce electricity which was affordable, as well as their object was that the electricity should reach each and every district of India. There is legality of object behind the above mentioned contract. Without an object, there will be no purpose to the agreement or the contract. An agreement which is enforceable by law becomes a contract. The purpose of this lecture is to make you understand why objects should be always lawful and also to help you distinguish between void as well as unlawful agreements. Now let us discuss about unlawful agreements as well as void agreements. We will distinguish between both. First and foremost, let us go with the meaning. An unlawful agreement is an agreement whose object or consideration is forbidden by law or is opposed to public policy. For illustration, agreement to smuggle gold into India or an agreement to go forward with adulterous relationship which is opposed to public policy. All these are examples for unlawful agreements. Let us now look into void agreements. An agreement which is not enforceable by law becomes a void agreement. For an illustration, a contract with a minor will be considered to be void ab initio. When it comes to legality, an unlawful agreement will always be considered illegal, but it need not be the same way when it comes to a void agreement. They are just not enforceable by law. Unlawful agreements are not just void but also punishable by law. For an illustration, an agreement to smuggle gold in India can be deemed to be void, and also for going forward with such transactions, the Indian laws recommend and punish people involved in smuggling. Void agreements. They are only void without any punishment. The contract law always goes forward with compensation, damages, etc. There is no such thing as a penal law. When it comes to collateral transactions, even the collateral transactions will be considered as void. For an illustration, let us suppose that A took a loan from B and later on they devised an agreement to smuggle gold into India. Here, the first agreement to borrow money was also tainted and held void because it was a part of the collateral transaction. Void agreements. The collateral transactions under the void agreements will be considered to be valid. For an illustration, let us suppose that There was a boy named Sandeep who wanted to become a pilot. He was a minor. He misrepresents his age before the recruitment agency and states that he has flown for so and so hours and confidently answers all the questions posed. And then he is selected. But on the day of his first flight, they come to know that he is still a minor. So all these transactions which happened were valid. It's just that the end result became void because of the minority of the boy. All unlawful agreements are void, but not all void agreements are necessarily unlawful. Let us look into Section 23 of Indian Contract Act, which lays down the various unlawful agreements. The first one is agreements which are forbidden by law. In Sushila Devi versus Hari Singh, a land was lent on lease to somebody. The land was situated in India. But what would happen as soon as partition and if the land is given to Pakistan? The answer is the lease agreement would be rendered void as well as forbidden by law due to the act of partition. The second type of unlawful agreement is an agreement which defeats the provisions of law. A is a money lender who is lending money to B at an interest rate of 60%. But the law of the land says only 30% is the interest leviable. Here, the moneylender is defeating the provisions of law. In Foster versus Driscoll, there was an agreement to smuggle whiskey into USA. This was an agreement which defeated the purpose of law as well as was deemed to be forbidden by law. The third type of agreement which will be rendered unlawful is a fraudulent agreement. A and B enter into an agreement to file a fake insurance claim after a short circuit, which they themselves initiated. In Pierce versus Brooks, a carriage was lent for the purpose of prostitution. This was held to be against public policy as well as fraudulent. The fourth agreement, which will be rendered unlawful, is agreement to injure a person or property. A and B agree to beat up C. This is an unlawful agreement. And the final one is an agreement which is immoral as well as opposed to public policy. If there is an agreement to go forward with second marriage, it would be called as bigamy, except for Muslims, other religion people. It will be called as bigamy, which is a penal offense in India. In Gharelal Parekh versus Mahadev Maya, it was held that wagering agreements are void but not unlawful. Wagering agreements are nothing but agreements which are dependent on chance. That's why horse racing in India, though they come under wagering agreements, they still happen. They will not be considered unlawful in India. Thus, I would like to conclude by stating that all unlawful agreements are void, but not all void agreements are unlawful. The various unlawful agreements are agreements forbidden by law, agreements which defeat the provisions of law, fraudulent agreements, agreements which are injurious to a person or property, and agreements which are immoral or against public policy. An agreement with a minor will be called void ab initio, but it is not unlawful. Object brings in a sort of purpose into a contract. If the purpose itself is unlawful, those agreements will be considered void ab initio. Thank you for listening to my lecture on legality of object under the Indian Contract Act. Do let me know in the comments the distinction between unlawful as well as void agreements. And Do tell me in your own words what is exactly object and why is legality of object required for the purpose of becoming contractual parties under the Indian Contract Act.